Start. The first are the appeals arising from the judgment passed by the Gujarat High Court declaring Section 145 of the Gujarat Provincial Municipal Corporations Act 1949 as ultra vires in the Constitution and on that basis interdicting the levy of property on mobile towers. The High Court, by the impugned judgment, however, took the view that the cabin in a mobile tower in which BTS system details of which are noticed below is located would be a building and therefore exigible to tax under the Gujarat Act. The state government and the different municipal corporations have challenged the first part of the order of the High Court, whereas the cellular operators have challenged the latter part. The Bombay High Court, which was in session of somewhat similar challenge by the order under challenge, has taken the view that the writ petitions challenging the levy of property tax on mobile towers should not be entertained and the aggrieved writ petitioners therein should be left with the option of exhausting the alternate remedies provided by the Act. This would be the third category of cases. In this regard, it must be noticed that in the Bombay Provincial Municipal Corporations Act 1949, the charging section does not specifically contemplate levy of taxes on mobile towers as in the Gujarat Act. The impugned levy nevertheless was imposed on the reasoning that mobile towers are buildings as defined in the Act. At this stage, it must also be noticed that the Bombay Provincial Municipal Corporations Act 1949 was applicable to the state of Gujarat also until the year 2011 when by the Gujarat Short Titles Amendment Act 2011 the word Gujarat has been inserted in place of the word Bombay. The fourth and fifth categories of cases would be the writ petitions arising identical issues which have been transferred from the Bombay High Court to this court and the writ petitions filed before this court by the cellular operators under Article 32 of the Constitution raising a similar challenge as in the writ petitions filed before the High Court. As the elaborate arguments advanced in the course of the prolonged hearing have centered around the provisions of the Gujarat Act, it may be convenient to take up the Gujarat cases in the first instance. The answer to the issues arising therein would in any way effectively decide the issues arising in the Bombay cases also as well as in the transferred cases and the writ petitions filed under Article 32 of the Constitution. The aforesaid Gujarat Local Authorities Laws Amendment Act 2011, similar provisions for levy of tax on mobile towers have been inserted in the Gujarat Municipalities Act 1963 and also the Gujarat Panchayats Act 1993. The short contention of the cellular operators advanced before the High Court is the Section 127 1C read with Section 145A of the Gujarat Act are legislatively incompetent as mobile towers are beyond the scope of Entry 49 of List 2nd of the 7th Schedule of the Constitution. Two significant aspects connected to the issues arising may be taken note of at the outset. The meaning of any legislative entry, example taxes on lands and buildings, should not be understood by reference to the definition of the very same expressions appearing in a statute traceable to the particular legislative entry. In the present case, though the Gujarat Act defines the expressions land and building as rightly held by the High Court, it would be self-defeating to understand the meaning and scope of Entry 49 of List 2nd by reference to the definition clauses in the Gujarat Act. Definitions contained in the statute may at times be broad and expansive beyond the natural meaning of the words or may even contain deeming provisions, though the wide meaning that may be ascribed to a particular expression by the definition in a statute will have to be given effect to if the statute is otherwise found to be valid. It will indeed be a contradiction in terms to test the validity of the statute on the touchstone of it being within the legislative entry by a reference to the definition contained in the statute. The second aspect mentioned above is one concerning the permissible operation of two different statutes relatable to two different entries in list first or second or even in list third of the seventh schedule of the Constitution. This has been acknowledged by the High Court in the impugned order by accepting that even if a mobile tower is a part of the apparatus pertaining to telegraphs covered by entry 31 of list first, yet the Gujarat could Act still coexist as a statute levying a tax on lands and buildings so long and if only mobile towers can come within the scope and ambit of the aforesaid expressions. Land and building in entry 49 of list endeavor and therefore must be to trace out the true meaning of the expressions land and building appearing against entry 49 of list second by a correct application of the parameters and principles governing the interpretation of a constitutional provision, especially an entry in any of the legislative fields under the 7th schedule 2 of the constitution. Certain accepted and settled principles of constitutional interpretation may now be taken note of. It will not be necessary to enter into any detailed deliberations and debate in this regard in view of the undisturbed precedents on which such principles have come to rest. Broadly and illustratively, some of the principles which have been culled out from the decisions of this court. Though Article 246 has often been understood to be laying down the principle of parliamentary supremacy, it must be qualified that such supremacy, if any, is extremely limited and very subtle. This has to be said when the federal structure of the Indian Union has been recognized as a basic feature of the Constitution. Both the central and the state are competent to enact laws in any matters in their respective list, that is list first and list second.